In this case, a defendant facing serious child assault charges gets a shocking deal. The judge drops a critical enhancement, the sentencing range shrinks from 10 years down to just 3, and a guilty plea seals the fate. But is this justice, or a dangerous loophole? Stick around, because what happens inside this courtroom will leave you questioning the entire system. And if you never want to miss these jaw-dropping moments, make sure to subscribe right now and join us for every twist inside the courtroom.
Okay, I'm looking at the indictments which allege first-degree felonies of sexual assault of a child. We're going to be voting on attempted. Yes, sir. Isn't that 1 degree less?
Okay, let's pause here. What the judge is wrestling with is the difference between a first-degree felony and a third-degree felony. That's not just legal jargon, it's the difference between decades in prison versus potentially walking out in just a few years. This plea deal could be a lifesaver for the defendant but a gut punch for the prosecution. Do you think justice is really being served here?
Yes, but these are third degrees. From a first degree to a third is not 1 degree less.
The agreement was to drop the first degree enhancement. There's an enhancement in the indictment.
What
Is
is
it a first? It alleges
The child being under the age of, I think, what is it?
no,
younger than 17?
it's the familiar relationship.
Oh, is it? Let me say, I
It alleges a familiar relationship.
don't think.
It doesn't. Does not.
I think it's just.
Yes, but he was psychologist. That makes sense.
Can I see the indictment, please, sir? I don't have my file. Can I see your indictment? Yes, sir. There's an enhancement down here under this last paragraph here. It says have a familiar relationship or prohibited from having sex with because of that relationship. So we're abandoning that and just proceeding on the second degree and then dropping it down to a first degree. This that prohibited from having sex under 25 World 2, I believe, or something along those lines.
Oh.
That makes it a first degree. So we're just abandoning that. We're abandoning that language, making it.
It just referred to the statute.
Yes, sir. Then we're just making it a second degree and then reducing, doing an attempted. So abandoning the language of the familial part.
Okay. Well, there's no language that says that, but it just refers to the general
Yes,
section of 2502.
Yes, sir.
Did you catch that? The judge just confirmed they are abandoning the familial relationship enhancement. Why does that matter? Because that enhancement is what made the charge even harsher. By removing it, the legal hammer just got a whole lot lighter. Imagine cutting the weight of a sentence in half with one ruling from the bench.
And this is 429. What are we going to do with 430?
Same thing. Same exact thing.
Okay, in each of these cases, does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
He doesn't with my earnings.
In summary, in cause numbers 23 CR 429 and 430, in summary, these indictments allege that on or about June 1st, 2020, in cause number 429, and on or about August 31st, 2020, in cause number 430, in Jefferson County, Texas, it is alleged you committed the first-degree felonies of sexual assault of a child. Do you understand what you're charged with in each of these cases? Agreements have been reached in each of these cases. You will be pleading guilty to the lesser included offense of attempted
sexual assault of a child. Yes, sir.
sexual assault of a child. In each case, which would be third degree felonies in the way the case is indicted under section 2502. that would be dropped,
That is abandoned, yes, Your Honor.
abandoned by the parties. So the lesser included offense becomes a third-degree felony of attempted sexual assault of a child under these circumstances, which means in each of these cases you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Now this is where things get really tense. The maximum sentence could have been 10 years, but thanks to this plea agreement, the cap is 3 years. 3. For attempted sexual assault of a child. What's your reaction here? Fair justice or a deal that feels dangerously lenient for the defendant?
Yes, sir.
Agreement has been reached. Whatever sentence shall not exceed, is that 3?
Yes, my handwriting.
Yeah, it's sort of. Whatever sentence shall not exceed a cap of 3 years in prison. So what we have here are the options, which would run concurrently with each other. So you're looking at no less than 2 nor more than 3 years confinement in prison.
That's correct.
Deferred or unadjudicated probation could be assessed. Is regular probation
I don't think
an
so.
option under these circumstances?
I don't know if it's an attempted, it might be.
It's involving a child less than 17.
10 cells usually are 3G as well, right?
Not necessarily.
Anyway, there's going to be a plea agreement, a pre-sentence report prepared. We will all come back, review it, make sure that it's true and accurate. Each party gets to sound in, and then the court will make its decision. Is that your understanding of what's going to happen? If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
And again, how do you plead here to this lesser included, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Yep. Voluntarily, understand it, discuss it with your attorney, or the content's true and correct.
There it is, the guilty plea. Notice how the judge carefully walks him through every right he's giving up. No appeals, no trial, no second chances. It's official, the courtroom has his confession. But now comes the real question, how will the sentence actually land on July 15th?
State's Exhibit 1 is tendered into evidence and without objection is tendered. Among other things, this states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. And all of this is true. The state still help you guys. State's Exhibit 1, part of the record for all purposes. Pre-sentence report will be prepared to come back on
July 15th.
July 15th. Everybody will sound and the court will make its decision. Do you understand? Okay. That is all. It'll reset.
Yes, sir.